Hello, very good morning to you. Thank you so much for staying here on the AM show. Earlier, Benjamin Akapu brought you our first big story. It's now time to delve into the second, and it has to do with the MP for Assin North, James Gyakye Quayson, and the court processes involved in he not holding himself as an MP until a substantive case against him is heard. His appeal at the Supreme Court, the back and forth. Yesterday we were in court again and the case was adjourned, and his lawyers are not too enthused about that. Meanwhile, this is working to the disadvantage of the NDC minority in Parliament. They are losing one man. And you know the dynamics in Parliament at the moment and how it's important for everybody to have at least all men, especially when it comes to critical votes like what we saw last week, Friday. I've been joined this morning by Sami Obing. He's with Parliamentary Network Africa. Thank you so much, Sami, for joining us. I want to believe you've been following this case, and lawyers of James Gyakye Quayson have raised concerns. Some also believe the case is dragging too much. What are your thoughts?
Well, thank you very much. Certainly, this is a very important case. You have given a critical background to the issue, especially relating to representation of the people. The people of the Assin North constituency certainly must not go unrepresented. There is also the situation of the Parliament of Ghana having very close numbers, which makes the absence of any member or the absence of any constituency from being represented in a very critical situation. It's been close to a year. I think the ruling of the Supreme Court restraining the honorable member of Parliament for Assin North from holding himself as a member of Parliament was on the 13th of April last year. And so for close to a year, the people of Assin North have not had, representation in Parliament. And that has grave consequences of the people of Assin North. And I think that these are matters that we need to, be concerned about as a people.
Do you agree with those who say that this is probably deliberate, or, from your own following and appreciation of what's been happening in court, you disagree?
It may not necessarily lie in my mouth to make such a grave allegation at the apex court of the land, at the Supreme Court, that delaying a case like this or the delay in that case is deliberate. It will not lie in my mouth so to do, except to say that it is our expectation that the Supreme Court certainly appreciates the circumstances, surrounding this case, appreciates the situation of our current Parliament, appreciates the fact that it will be grave injustice on the part of the people of Assin North if they continue to stay without representation. Sometimes these allegations or concerns get raised when we are having one too many instances of cases that ordinarily, or every right-thinking Ghanaian may expect that will be dispensed of speedily, delaying. You recall that, and I want to use an example, you recall that a group of civil society organizations, Parliamentary Network Africa included, filed a case in the Supreme Court on the issue of the circumstances that led to the former Auditor General being asked to, proceed on leave and subsequently being taken, subsequently losing his office. And for a matter as important then, for a matter as critical then, for a matter that timeliness was of importance, it would surprise you to note that that particular case, almost 2 years down the line, has not received any hearing really from the Supreme Court. And as civil society, we still wait for the Supreme Court to, summon, call that particular case. And of course, we're having a situation where you have a very close Parliament, very limited numbers difference of numbers of MPs on either side. You have a constituency that is not represented. This is all laced in the backdrop of having the people of South also not represented in this particular parliament, and the conversation that came around it. And so to see that, another constituency has for one full year not been represented in parliament is a bit problematic. Let us be mindful of the fact that the constitution of our country gave an indication, in my opinion, of the need not to make any constituency suffer from being represented in parliament, to the extent that Article 112(5) of the Constitution, which spoke about Article 112 of the Constitution, which spoke about how a member of parliament who has lost his or her seat can be replaced. was very clear in the processes. And I think that the timelines that it gave, were so that we do not have people losing representation in parliament. It says that if a vacancy, is created in parliament, the clerk shall notify the Electoral Commission within 7 days of the information coming to the attention of the clerk or of parliament, and also within 30 days from that notice, that information being clear, the Electoral Commission shall ensure that a by-election is held. In fact, in the case of when an MP loses his or her life, then, of course, the Constitution stretches it to about 60 days, within which, of course, for cultural reasons and all of that, within which, by-elections needs to be held, which means that worst-case scenario that the Constitution envisaged was that 60 days after, a group of people in a constituency do not have representation, they must find representation. So 1 full year of the people of Assin North not having representation in parliament is really, in my opinion, grave injustice to the people of Assin.
But it's interesting. I'll allow you to digest this question. I'll go to Victor Dawudu, who is a member of the NDC legal team representing James Quayson, and I'll come back to you. Do you then see a bit of silence in respect of how the Constitution deals with this peculiar issue, which has to deal with a court case which is yet to be determined? But let me welcome Victor Dawudu to the program. Good morning to you, sir. Thank you for joining us. A member of your team, who is also an MP himself, Roxin Dafiamepo, is reported to have said that the adjournment of this case was done without any proper reason being given. Does your team sense that this is a deliberate attempt to delay the case?
Yes. Good morning, Venice, and good morning to your cherished viewers. I think that is a worrying development. In as much as the Supreme Court controls its cases, it manages its cases. The trend which where the cases have been adjourned and the good people of Assin North do not have a representation because there is an interlocutory injunction on their member of parliament, and nothing is seen being done, and cases being adjourned. I think it's a worrying development for everybody and for constitutional democracy. So yes, that is a position which most of the members of the NDC also ascribe to, especially when you compare cases which were involved in electoral matters. Example I can give you was the issue of the South, the Hokwe constituency and the South. That matter, there was an injunction in the Hope High Court granted, and quickly that matter was sent to Supreme Court and it was disposed of. So what is making this particular case over a year, almost a year, that the case is not being heard? What was the agency about the case in Hope? And does it mean that this is not also agent? Is it not the same electoral dispute? So if the court itself has asserted that electoral disputes should be given that agency in dealing with the matter, that gives you a cause of worry. And I think that it's in place because the people of Assin North have been denied representation. And these are the new jurisprudence we are seeing in our constitutional law and our constitutional electoral laws that we are seeing. And that does not give the Supreme Court a very good image when it comes, especially to the interpretation of the cases, and especially cases that have political undertone and electoral undertones. It does not give them a good image at all.
Right. My other guest has eloquently explained the impact of this on the constituency he represents. But what has this delay cost your client? What's the cost of this delay to him personally?
Hello?
Hello, can you hear me?
Yeah, I can hear you now.
I'm saying that we've already explored the angle of the cost of the delay to the constituents that Mr. Quayson represents in Parliament. But I'm asking you to tell us what the cost is to him as a person, his personal life, what this delay is costing him.
Yeah, I think the delay is affecting him so much. How to go about his legitimate work, whether to represent the people or he's representing the people or not. There must be a conclusion to this matter. And if we bring closure to this matter, he will know his fate. The people of Assin will also know their fate. Now, his fate is hung in the balance. And especially, this is what the same Supreme Court talked about in the case of Isaac Amu in 1996. The case was hanging in the court, and the same court realized that it was not right that a case pending before the court will be there until the person who has been sent to court, rather, the term expires. So the court does not do anything, only at the tail end, when the term of office is getting to expire, you come with a judgment. So when you come with a judgment, so there is an example which the Supreme Court itself has condemned, or people have condemned that what was done by the Supreme Court, and we see the same thing repeating itself. So does it mean that history is not teaching us, or it's the payback time?
Interesting.
Yes, these are things that we think, and we think that, yes, it is not good for him as a person. He doesn't know what to do for now. But if closure is brought to this matter, his people, the constituents, and he himself will know what is the way forward for him.
So there are two separate cases. There's the one at the Supreme Court, which is an injunction restraining him from holding himself as an MP and representing the people, which he's seeking an appeal and a review to. There's the other case being heard in the High Court, which is a criminal case. What's the update on that as well?
Yeah, there's a criminal case that is pending before him. I am not directly in charge of that case, so I will not be able to. What I know is that it is still pending. They are yet to start the hearing and others, but I cannot specifically tell you this is the stage that they are got into. But it is what I know. It is pending, and proceedings are yet to start in that matter.
This case has been adjourned. Are you confident that when the next hearing day arrives, you will have that opportunity that you so desire to make a case for your client to be allowed at least to represent his people while that case in the High Court continues?
No, I think there are two different cases. A civil case in the Supreme Court and a criminal matter in the High Court.
Yeah, exactly the point I'm making. I'm saying that are you confident of the adjournment of the case at the Supreme Court, which has to do with he being restrained, the injunction, right? Are you confident that when that case is next heard, you will be given the opportunity to make your case?
No, I am not directly the leading. I think it's Mr. Gyakye Quayson who is leading that matter with my friend Justin Fabra. We are just behind, also giving the necessary support. But I believe that, yes, what the Supreme Court has to do, it must be seen to be done. As the adage goes, or the phrase goes, that justice must be done, must not only be seen to be done, it must manifest. People should see that justice is being done. And if that is not being done, it's not being heard, people may lose that confidence that they have in the judiciary by the way things are being done. And I don't think it will augur well for us. The Supreme Court and the rest will be the last bastion where we can go and seek redress. But if we have a bad perception or image of it, or there's a block on it, I think that it does not augur well for our clients and even the general public.
I'll come back to you for your concluding remarks on this matter. Back to you, Samuel Bing. So on the issue of the Constitution and whether or not there are clearly prescribed remedies for situations like this, and what this opportunity should afford us in the conversations about the review of the Constitution.
Well, Bernice, over the lifespan of the 1992 Constitution, we've had quite a number of cases relating to challenge of parliamentary elections, in court. In fact, in recent times, the presidential bit has also joined in. In all of these cases, I think that there are useful lessons that can be learned on the issue of timelines and perhaps strengthening some of these issues in the Constitution should there be a review of the Constitution. It's, however, important to note that in this particular case, the case was actually heard in the High Court. Mr. James Quayson was declared as, his elections was declared as null and void in the High Court, which means that ordinarily, if the issue was not challenged, in my opinion, then, it would have been he having lost his seat, and then the processes will continue. But of course, he has the right to be able to bring the matter up. But in this case also, it is important to note that, per my understanding, it is the plaintiff in the case in the High Court who again went to the Supreme Court and said that, well, the High Court has ruled that, this man cannot hold himself as a member of Parliament. However, he's still holding himself as a member of Parliament. So I need you to injunct him from holding himself as a member of Parliament while the other matters, gets dealt with. And that is where the High Court the Supreme Court actually made the ruling. But certainly, we cannot have a situation where, look, the 2021, population and housing census, indicated that the people of the Assin North district are a little over 80,000. We can't have a situation where timelines, delays in court situations and what have you makes it possible for over 80,000 Ghanaians to not have a voice in the legislative arm of government. I think that is, for me, the biggest situation that the Supreme Court must lend its mind to.
And so do I get a sense that what you're saying is that due to the sensitivity of this case, the Supreme Court should expedite and come to a conclusion on the matter?
Well, I think that the Supreme Court, being masters around some of these procedures, is able to do that. We saw how there were some very elaborate rules on how the presidential election petition can be dispensed of, being mindful of the implications. This particular one, especially with the kind of parliament that we have, the kind of numbers that we have, and the situation we've been seeing in parliament over the past 2 years, should certainly make the Supreme Court want to deal with this matter expeditiously.
And unlike the situation where you have, for example, when Mr. Alan Trematin resigned, you have, the president appointing someone as a caretaker minister, or the deputies, doing the work while they wait for a substantive minister to be appointed. It's not the case for MPs. How do you see moving forward? And again, because there are conversations around the review of our Constitution, and these scenarios and situations give us the opportunity to think about other angles that may not have been so clear at the time that the Constitution was being framed. What should we begin to look at? Yes, it is a one-off situation, but it's denying people a representation in Parliament, a very important representation in Parliament. So what are the options for you while we look at this case and ensuring that it doesn't, deny people the opportunity of being heard or represented?
Yeah, Bernice, you see, this may be the case of Mr. Quayson, but we've had similar cases in the past on, dealing with matters relating to challenge of the eligibility of the election of a particular member of parliament in the past. And these should teach us lessons. In fact, constitutions are made based on, historical antecedents, based on what has happened in the past and all of those things. So certainly our past records as a country should be able to direct us on ensuring that at least there are some clear timelines. I mentioned to you earlier the provisions of Article 112, specifically relating to filling in a vacant position. The Constitution was very clear on the timeline so that we do not have a situation where the Clerk of Parliament, upon learning that a seat has become vacant, will delay in communicating to the Electoral Commission, or a situation where the Electoral Commission also, upon learning from the Clerk of Parliament that a seat has become vacant, delay in holding a by-election. So the Constitution was very clear. It gave specific timelines. I think that we are getting to the stage where, some of these things must be considered, especially as the country generally thinks about a review of our constitution, so that there are clarity on, what needs to be done in some of these instances. So we don't have instances where somebody is held, is made not to hold himself or herself as a member of parliament for so long that by the time that the case is dispensed of, the tenure, which is a fixed tenure of 4 years, is actually over.
Thank you so much, Samuel Bing. And your final words, Lawyer Adowudu. I can imagine how important this is to your party, the NDC, considering the current dynamics in Parliament. Has this come up recently at NEC meetings or other meetings of high-ranking officials of the party? And what has been the discussion on the way forward, if any such discussion has happened?
It will be a bit difficult to answer as from the party echelon what the discussion has gone, because I don't belong to FEC or NEC. I don't belong to them. But I'm sure that it might be issue that borders on some very sensitive matters that the party will take, is jealously guiding and following to see the development in it. But I think that the Supreme Court must do justice for the people to see that, yes, we are doing justice. I think that repeating what happened in Isaac Amu versus Adete in 1996, repeating itself will be a blot again on the conscience of the Supreme Court, because that is what was done and that is what is being done again. And I think that people can clearly see. And the comments that were made by critics after the decision in Isaac Amu, when the term or the tenure has elapsed, and the Supreme Court comes and says that, yes, actually he was the rightful person to represent, that he had been denied. I don't think that history will serve us right, or posterity will serve us right, if we do the same thing. So I would only say that let's bring closure to this. The fact that the Supreme Court manages its own cases, I think that, yes, like my colleague Samuel Ben said, there should be, the timelines are clear in the Constitution. But now we have seen the development where the Supreme Court says that there can always be an injunction. We have seen two different, in the High Court, they said there cannot be an injunction, they need representation, but Supreme Court says that there can always be an injunction. So these are conflicting decisions, but with our cases, hierarchy of cases, what Supreme Court says binds all the other courts unless they have departed from it. So I think that all I'll say is that the Supreme Court is there, the judiciary is there to serve the people, protect the people, serve their interests. And if they are doing something that people think that is untoward, is not serving their interests, they live within society, and the voice of the people is the voice of God.
I appreciate your time here this morning. Victor Kujogan Adawudu is an NDC lawyer, and he was in court yesterday for James Gyakye Quayson. He is MP for Assin North, who has been restrained from holding himself as such. He's reviewing, or he's seeking a review of that in the Supreme Court, and the case was adjourned to April 5. His lawyers are concerned that the case is dragging unnecessarily. We'll be following up on this and let you know what happens and transpires in court. Now, we will be back to have that conversation about Joy Changemakers Tuesday.